Here's your shot at winning $1,000. Text the national keyword NOTE right now to 95819. That's NOTE to 95819. We'll text you back to confirm your entry. Data and messaging rates may apply. Please don't text and drive. It's 5K a day on WMAL. Now on 105.9 FM and streaming worldwide on the WMAL app. O'Connor and Company.
It's 7:07. Thank you for being part of our morning conversation here on O'Connor and Company. Busy news cycle that we're trying to navigate through and make sense of. Coming up in 30 minutes, Nick Minnock will give us a preview of the election in Virginia in 4 weeks. No, not the governor's race or even the attorney general's race. We may get into it, but Loudoun County, you got a school board up for grabs here with 5 seats on the ballot. Then at 8:35, the inimitable Ambassador Rick Grinnell, president of the Kennedy Center. We're going to talk all things Stuttgart, which I like with a side of sauerkraut and some of that brown mustard. How about you, Julie Gunlock? How do you like your Stuttgart?
Same.
Sure, that's the only way to get it. That's what the purists do. Joining us right now, Alex Swoyer. She's an attorney and the legal affairs reporter at the Washington Times. Her book, Lawless Lawfare, Tipping the Scales of Justice to Get Trump and Destroy MAGA, is a kind of important reading if you want to make sense of the indictments that just came down for James Comey and, well, all the indictments we should be waiting for. Alex, thanks for joining us.
Yeah, thank you. I have been waiting for some more indictments, especially, following all that reporting and what we were told by Gabbard earlier this year. So more to come, I'm sure.
Meanwhile, you're putting on your legal analyst hat watching the Supreme Court right now in a couple of important cases as the session just began. Yesterday's had to do with so-called conversion therapy. There are a lot of states, including Colorado in this case, have banned psychologists, therapists, psychiatrists from engaging in what was called conversion therapy. And this involves children who are feeling, well, let's say a child is feeling gender dysphoria and they have an urge to dress up like the opposite sex. If a parent brings a child into a psychologist and said, listen, can you help our child overcome these desires? The doctor is not allowed to do that. They're only allowed to affirm and say, yes, absolutely, dress up like a girl.
Right.
Is that how I'm understanding this?
Absolutely. Or even if the child says, I want help with this, that I'm confused and especially a family of faith, that would be problematic in the state of Colorado. I think there's 22 other states that have similar laws like this. So this is, for minors, and it regulates essentially, the medical profession, licensed therapists, and what they can counsel. And so you had a Christian counselor out of Colorado go to the Supreme Court and say, this is a viewpoint discrimination under the First Amendment, which is unlawful. You can't have the government favoring one type of speech, like what you just mentioned, a counselor saying, encouraging a youth to transition, versus a counselor that's trying to encourage youth to better identify with their faith, help them through the struggling times. The lawyer for the Christian counselor noted that I think 90% of youth that struggle with gender issues usually, outgrow it or overcome it and realign with their biological sex. So there was the feedback from the justices in the courtroom. I think Alito said it was, quote, blatant viewpoint discrimination. Justice Barrett even told the Colorado Solicitor General, arguing to defend the case, that she didn't really follow her argument, which is not what you want to hear when you're the lawyer making, before the justices trying to defend the law. And seems confused about what if there's no consensus in the medical community, right? Some studies suggest conversion therapy, it's harmful, doesn't work. Others, push back on that. What I just talked about, 90% of youth that actually, return to their biological sex, that go through those confusion stages with gender dysphoria. So, yeah, I kind of got the feeling that Colorado's law had, the justices were looking at it kind of skeptical.
It's so interesting, Alex, and this is so critical because you talk to, at the Independent Women's Forum, we do a lot of work on this and interview parents who have been through this, and they often report that when they take their child to a psychiatrist because their child is dealing with gender dysphoria, often, I shouldn't say often, in every single case, and I've talked to also friends who've been through this, in every single case, their child is affirmed. Even when that parent says, can you please not affirm them? I'd like you to, talk to them about their gender dysphoria. So this is critically needed in in that industry itself,
Yeah.
because we see this, Abigail Schreier has written about this sort of, trend, especially among girls. So this is really needed in that industry. Isn't that right?
Yeah, no, I think you're exactly right. This reminds me of when I was at the court the last term with the case out of Tennessee where they banned medical treatment for transgender youth. That was challenged. That was not a First Amendment challenge. That was actually under equal protection. The justices said states can regulate that. But yes, I think that there is this, during those arguments, there is this push that if you don't affirm a youth's questions about their sex, or their questions about if they need to transition, then you pose a risk about suicide. And
Yes.
I think that the most recent studies have shown actually that that's not true.
Right.
That the problem actually, it comes that there's a lot of mental health issues and even physical health issues when these puberty blockers
Yes.
and other forms of treatment are pushed on them too soon, right? So,
Yeah.
I think this is an important topic.
There's also an importance here in terms of therapists and how they're sort of categorized by the state. Everyone will think that, there are doctors. This is a medical and science-based thing. Well, no, actually, you can be a licensed therapist by just having a Bachelor of Arts degree in psychology, not necessarily a science degree. And everyone's like, oh, it's a medical-based practice, and this is based on science. I'm sure that was part of the state's argument, but this isn't actually based on science, and you can easily be a therapist with a different kind of perspective that isn't science-based, and should they have the freedom to be able to do that? This really is kind of a First Amendment thing, isn't it?
Absolutely, yeah. And I think it was obvious, just when you said that some counselors would not have an issue encouraging their client to transition, but those that are seeking to help to realign with their faith that can't speak on that, obvious First Amendment issue there. So I got the feeling the court was going to be sympathetic to this therapist. And something else to note is she can't even prescribe drugs. Her practice is all speech related. So that's another thing to consider.
Yeah, exactly. There's people have to understand there are therapists, there are psychologists, and then there are psychiatrists. I think it's only when you reach the level of psychiatry do you actually have a science degree to
authority
prescribe drugs.
To be able. Right. Exactly.
Yeah. That depends on the state, though, too. I know that there's been some push in some states. Hey, Alex, can you stay? Because I know that there's an argument today about mail-in ballots, and I want to dive into that. Stick with us for just a quick 1-minute break here, and then we'll get into that with Alex Swoyer.
WMAL, making sense of the news. Live from the Home Paramount Pest Control Studios. Home Paramount, the leader in pest control since 1939. Your next $1,000 could be one text away. It's $5K a day on WMAL.
There's a bit of a surge in election-related litigation that the Supreme Court is trying to wade its way through, and lower courts as well. And so they're hearing arguments today, and it has to do with standing. Is that right? But oftentimes these arguments over standing are critical in terms of who can sue over things like, stop counting ballots 2 weeks after Election Day. That's a violation of federal law. Is that what we're looking at today, Alex?
Yeah, so you're exactly right. If you remember during the 2020 election, I think all of us are, old enough to remember that, there was so much litigation after those results about mail-in ballots. And a lot of the cases were dismissed for various reasons, never really reached the merits. And what you have now are certain lawsuits that have challenged states that count ballots days after Election Day. So the one today is before the Supreme Court out of Illinois. You have a Republican congressman out of Illinois, represented by Judicial Watch, who is challenging Illinois' law, which allows ballots to be counted 14 days after Election Day, 2 weeks, like you just said. And the lower courts dismissed the case, saying that he does not have standing to sue. Standing is basically legal injury. And he was saying, no, I have to pay, my campaign has to pay election monitors extra days, right? So that's an injury, financial. But the Supreme Court has decided to review that lower court decision on the standing issue. If a federal candidate doesn't have standing to say, hey, federal election law has, or, there's one federal election day, so I'm challenging my state counting for days after that, then who would have standing is a good question. And then beyond, the reason this is so important is not only about who can sue, but there's another case pending. And I don't believe it was rejected earlier this week when the justices returned. It might have actually been relisted. I'll have to take a look. But there's been another big case where it was out of the Fifth Circuit, conservative circuit, that ruled against Mississippi's law, which had allowed 5 days after Election Day for mail-in ballots. So you do have at least some precedent at a circuit court level saying, no, like ballots shouldn't be counted past Election Day. Now, the question is whether the justices are actually going to take up a case like that and actually look at the days after. Can states do this? Can they set that law? This case today is just about who can challenge that. But it's basically, they're going to go hand in hand. If they say these federal candidates can go ahead and challenge these laws, I think you're going to see even more of these lawsuits in various states.
All right. Thank you for that update on yesterday's arguments on the conversion therapy thing and a preview of today's arguments over mail-in ballots. We appreciate it. Alex Swoyer, you're going to be very busy as these cases now. We're back in season for the Supreme Court.
Absolutely. And more Trump cases, too. Thank you, Larry.
Wow.
Yes, exactly. Yeah, well, and get ready for the next round of indictments. Get her book, Lawless Lawfare, Tipping the Scales of Justice to Get Trump and Destroy MAGA. Thank you, Alex Swoyer.
Thank y'all.